If you or a parent has ever received Medicaid coverage for a nursing home stay or for care provided at home through certain Medicaid programs, I want to walk you through a rule that catches families off guard more than almost any other rule I've covered on this channel. It's called Medicaid Estate Recovery, and in plain terms, it means that after the Medicaid recipient passes away, the state has the legal right, in most cases, to seek reimbursement for what it paid, often through the value of the home that gets left behind. I want to handle this topic carefully today because I know for a lot of you, this isn't an abstract policy question. It's about your parents' house or your own house and what happens to it for the people you leave behind. So let's go through this clearly, calmly, and completely, including the real protections that exist because there are more of them than most people realize. If you're not subscribed yet, take a moment and do that now and turn on the bell. This channel exists to walk through exactly these kinds of rules, the ones that affect real families and rarely get explained in plain language. Subscribe, and let's get into it. Let's start with what this rule actually is and where it came from. In 1993, a federal law called the Omnibus Budget Reconciliation Act required every state to operate a Medicaid Estate Recovery program. Before that law, states could choose whether or not to seek reimbursement after a Medicaid recipient died. Since 1993, every single state and the District of Columbia has been legally required to attempt this recovery, at least for certain types of Medicaid spending. Specifically, this applies to people who were 55 or older when they received long-term care services through Medicaid, things like nursing home care, in-home care provided through what are called home and community-based services waivers, and related hospital or prescription costs tied to that long-term care. It also applies, regardless of age, to anyone who was permanently institutionalized, meaning someone who was in a nursing facility and not expected to return home. If neither of those situations applies to you or your family member, this specific rule generally doesn't come into play. Now here's the misunderstanding I most want to clear up today, because it trips up nearly everyone who hasn't dealt with this directly before. While someone is alive and applying for Medicaid long-term care, their home is generally treated as an exempt asset, meaning its value doesn't count against Medicaid's asset limits for eligibility purposes. A lot of people hear that and reasonably assume the home is simply protected, full stop. But that exemption only applies to eligibility while the person is living. It has nothing to do with whether the state can seek recovery from that same home after the person passes away. These are two completely separate rules, governed by different parts of the law, and conflating them is exactly how families end up blindsided. So let's talk about who is actually protected, because there are real federally guaranteed protections here, and I don't want this video to leave you only with the scary part. Let me make the core confusion concrete with a simple example first, because I think it'll make the rest of this click into place. Say a widow in her 70s owns her home outright and needs nursing home care. When she applies for Medicaid, the caseworker tells her the home doesn't count against her asset limit, so she remains eligible. She passes away 2 years later, and her adult children, who don't live in the home and aren't disabled, inherit it. At that point, the state can file a claim against that home for the long-term care costs it paid, even though the home was never counted as an asset while she was alive. The eligibility rule and the recovery rule operated on two entirely different timelines, and that's exactly the part that surprises families. Under federal law, a state cannot pursue estate recovery if the Medicaid recipient is survived by a spouse, a child under the age of 21, or a child of any age who is blind or permanently disabled. This protection exists no matter which state you live in, because it's set at the federal level as a baseline that every state must honor. I do want to clarify one detail here. In some states, this protection is permanent. In others, it's more accurately described as a delay, meaning recovery is paused while those conditions exist, but could potentially resume later, particularly after a surviving spouse also passes away. Whether your state treats this as a full exemption or simply a delay makes a real difference, and it's one of the most important state-specific facts to find out early. States are also required by law to establish a process for waiving estate recovery in cases of what's called undue hardship. The exact criteria vary by state, but commonly include situations where the home is a family farm or family business that represents someone's primary source of income, or cases where an heir would become homeless or need public assistance if the home were taken. Many states also have a specific waiver for what's sometimes called a caregiver child, an adult child who lived in the parent's home for at least 2 years before the parent needed nursing home care, and who provided a level of care that genuinely helped delay that need. A similar exemption exists in many states for a sibling who has an ownership interest in the home and lived there for at least a year before the Medicaid recipient was institutionalized. Now here's where I need to be very direct with you about how much this varies. Medicaid Estate Recovery is a federal mandate, but the specific rules, the exemptions, the timing, and even the definition of what counts as part of someone's estate are set individually by each state. Some states only recover from what's called the probate estate, meaning assets that pass through a will or through the formal probate court process. Other states use what's called an expanded definition of estate, which can allow recovery from assets that pass outside of probate entirely, including jointly held property or accounts with a designated beneficiary. This single difference can determine whether certain estate planning tools actually protect a home in your state or not. The timing relative to a surviving spouse also varies significantly. In some states, like Florida, the state can still pursue estate recovery after a surviving spouse later passes away. In other states, like California and Texas, recovery is generally barred once there's a surviving spouse, even after that spouse later passes, unless the spouse was also a Medicaid recipient themselves. Most states also have a statute of limitations, a deadline for filing an estate recovery claim, which is commonly around 1 year after the recipient's death, though this also varies. None of this is one-size-fits-all, which is exactly why I keep emphasizing that your specific state's rules are what actually matter here, not a national average. I also want to explain something called a TEFRA lien, named after a 1982 law that gave states the option to place a lien on someone's home while they're still alive, specifically if they're permanently institutionalized in a nursing facility and not expected to return home. This is different from estate recovery after death, but it's related, and it exists to prevent someone from quickly transferring a home to avoid recovery later. Importantly, a state generally cannot enforce this kind of lien while a spouse, a child under 21, a blind or disabled child, or in some cases a qualifying sibling, is living in the home. Let's also talk briefly about how the actual recovery amount works, because there's a meaningful cap here. Medicaid cannot recover more from an estate than it actually paid out on that person's behalf. If the state paid $200,000 in long-term care costs over the years, and the remaining estate is worth $275,000, Medicaid's claim is limited to that $200,000 figure, not the full value of the estate. After a recipient passes away, the family or the estate's executor typically receives a formal letter from the state Medicaid agency notifying them that a claim is being filed, which also generally explains the right to request a hardship waiver if applicable. Let me answer 2 more questions I hear often. What about life insurance? Generally, a life insurance policy is protected from estate recovery as long as it has a named beneficiary other than the deceased person's own estate. Naming an actual person, rather than leaving it to default to the estate, is a simple detail that can matter a great deal here. What about a home owned jointly with someone else, like a sibling or an adult child? This depends heavily on how the property is titled and on whether your state uses the probate-only or expanded definition of estate I mentioned earlier. In some cases, property that passes automatically to a surviving joint owner outside of probate can be protected. In other cases, particularly in expanded recovery states, it may still be reachable. This is exactly the kind of detail where a generic answer isn't responsible, and where checking your specific state's rules with a professional genuinely matters. Now, I want to talk about planning, because while I'm not going to walk you through a do-it-yourself legal strategy in this video, I do want you to understand what kinds of tools exist so you know what questions to bring to a qualified professional. One option some families use is called a ladybird deed, formally known as an enhanced life estate deed, which allows someone to remain the owner of their home while they're alive, while automatically transferring ownership to a named beneficiary the moment they pass away, without that property going through probate. In states that recognize this type of deed and that limit estate recovery to probate assets only, this can be an effective way to keep a home out of reach of estate recovery. Another option is a properly structured Medicaid Asset Protection Trust. But timing matters enormously here, because transferring a home into this kind of trust generally needs to happen at least 5 years before applying for Medicaid long-term care, due to Medicaid's separate look-back rule on asset transfers. Set one up too late, and instead of protecting the home, you can accidentally create a penalty period that delays Medicaid eligibility entirely. This is precisely why I keep saying this isn't a topic to handle alone with a generic checklist, including the one I'm about to give you. The specific combination of your state's laws, your family situation, and your timeline genuinely changes what the right move is. I also want to gently address something I know crosses people's minds when they hear about the 5-year look-back period. Some families consider transferring a home or other assets to children quickly, outside of any formal planning, hoping to simply avoid this issue altogether. I want to be honest with you about why that's risky. Medicaid's look-back rule examines financial transfers made in the 5 years before someone applies for long-term care benefits. An informal, last-minute transfer made without proper legal structuring can trigger a penalty period, a stretch of time during which the person is ineligible for Medicaid, even though they've already given away the asset. That can leave a family paying out of pocket for care during exactly the period they were trying to avoid extra cost in the first place. This is the core reason proper planning, done early and with professional guidance, tends to produce far better outcomes than an informal transfer done under pressure. So here's what I want you to actually do. First, find out specifically how your state defines estate recovery, probate only or expanded, what your state's statute of limitations is, and how your state treats a surviving spouse over time. This information is often available through your state's Medicaid agency website, but an elder law attorney can confirm it accurately and explain how it applies to your specific situation. Second, if you or a family member is already receiving Medicaid long-term care, don't wait until after a death to think about this. Speaking with an elder law attorney while the person is still living gives you access to planning tools, like the ones I just described, that simply aren't available anymore after the fact. Third, if a loved one has already passed away and you've received a letter about an estate recovery claim, know that you have the right to ask about hardship waivers and exemptions before assuming the claim is final. Caregiver exceptions, sibling exemptions, and hardship waivers exist precisely for situations like this, and many families don't realize they can ask about them. Fourth, keep documentation. If you're an adult child who lived with and cared for a parent before they needed nursing home care, keep records of that timeline, since caregiver exemptions typically require proof of how long you lived there and what kind of care you provided. Fifth, if you're planning years ahead rather than reacting to a current situation, remember that timing is everything with tools like a Medicaid Asset Protection Trust. The 5-year look-back window means the earlier you have this conversation with a qualified professional, the more genuine options you'll have available when the time eventually comes. Here's the honest full picture. One more time. Medicaid Estate Recovery has been federally mandated since 1993, and it generally applies to long-term care costs for Medicaid recipients 55 and older. A home being exempt from Medicaid's asset limit while someone is alive does not mean it's protected from recovery after they pass away. Real protections exist: a surviving spouse, a child under 21, a blind or disabled child of any age, and various hardship and caregiver waivers. But exactly how those protections work depends heavily on which state you live in. Planning tools exist too, but most of them only work if they're put in place well before they're needed. None of this is meant to frighten you. It's meant to make sure a decision this important doesn't get made by default, simply because nobody explained the rule clearly until it was too late to do anything about it. Most families who go through this honestly say the same thing afterward, that they wish someone had sat them down and explained it plainly while there was still time to plan, rather than learning about it for the first time in a letter after a funeral. If you have a parent currently receiving Medicaid long-term care, or if you're planning ahead for yourself, send this video to the people in your family who will be handling these decisions someday. A short conversation now with the right professional can make all the difference later. That's what this channel is here for. Take care, and I'll see you in the next one.